Original side listed matters, item number 1 and 2.
Date দিয়ে দাও।
Item number 3, 4, 5.
For your lordship is for the Voltas matter, your lordship.
Yes.
That matters, the settlement talks are going on between the parties, your lordship. If you kindly grant us 2 weeks' time, we'll come with a settlement. My other set was just in court 2 minutes back, your lordship. So jointly we were supposed to seek prayer, but now he's not appearing.
Second week of May.
Second week of May. Grateful, your lordship. My other set, yes, your lordship. This is supposed
Second week of May.
your lordship, this is Kunal finance matter.
No, Voltas.
Voltas.
For the defendant.
Second week of May.
Item number 5.
My lord, item number 1, my lord, interim order is expiring today. Interim order is expiring today.
Adjourn to 7th May. Item number 1 and 2. Adjourn to 7th May. Interim order is extended till date.
Item number 5, my lord.
Item 5.
I'm appearing on behalf of defendant number 1 and 2, your lordship.
I appear for the plaintiff, my lord. I'm led by Mr. Shortcut. There are 2 applications that are pending. My lord, Mr. Shortcut is giving.
Commercial matter.
Yes, my lord, it is a commercial matter, one. And second is, my lord, the pleadings are not complete in this, my lord.
I'm releasing it then.
Very
The matter is released from this court for placing before
Master.
bench having appropriate determination.
And one more thing, my lord, your lordship's last order says, my lord, on 22nd of January, it's heard in part. So, my lord, that
I'm releasing it.
Your lordship, if I may, no, your lordship, if I may, plaintiff has filed one GS6 which says for the substitution of the members of the defendant company, which is a partnership firm. Your lordship raised one question that how is this application maintainable?
30.
Because section 63 of the Partnership Act was very clear. The plaintiff had to answer this question, your lordship.
Let
That
it be
is why,
placed
your
before
lordship,
appropriate bench.
that is
Because
why
my question was whether 22 or 30 will apply.
your lordship, yes, your lordship. So that is why it was written part 30, your lordship. So this question was raised by the bench only, your lordship.
And I have also taken this in my affidavit, this particular point. And for one of the proposed, I have taken this particular point in my affidavit.
very,
You raise it before the other bench, regular bench.
I'm grateful. My lord, I have misunderstood, my lord. Item number 3, I'm appearing on behalf of the LIC, my lord. I misunderstood that this is a original side is going on, my lord. Original side and commercial together.
This is original side matter. I have no determination in commercial matter only because it is part heard.
Yes.
I am better releasing this matter.
No, my lord. Is it part of related to my lord?
Okay. Then next day I will take it up. Date করে দিও ওটা। Item number 3, not your one.
Item number 6.
6 is my lord, I am for the plaintiff.
For the defendant.
It's the same problem.
Defendant's
Commercial.
application for amendment of plea.
But in a commercial.
I'm not a different written statement.
So this matter will be placed before the appropriate bench.
I have no problem. My duty to indicate it's a
Yes, that's a name number shows that. Since both of you are present, I'm releasing it. Otherwise, I would not have released. The matter is released from this court to place it before appropriate bench. Bench having determination.
Item number 7 and 8. For orders.
Make these a lot.
Of the day, I have not finished it.
Make these a lot.
In course of the day, we'll get it.
I'm very deep.
Extremely
Very,
grateful.
very deep. Your Blessing.
Extremely grateful. But only one thing, my lord, on the last occasion, my lord, your lordship has indicated that, my lord, if I can give me the order, please.
GA9, my lord, was.
Reserve for, your lordship has heard GN.
It is for GA9 only.
Oh, yes, sorry.
GA8 was not
Part heard. It is part heard. I'll not pass any order in GA8. GA9. GA9, of course.
I'm great.
Because there is a urgency in GA9. It should be decided. Whatever that might be, it should be decided.
I'm very grateful, Lord. Deep to your blessing.
Great.
GA8 is for substitution, I think.
And I am for the,
I think GA8 should be released by me before the proper bench, because that is not so important matter. Like this one is urgent.
because they are taking the objection in other.
I understand. Just now I took up one
taken
matter.
Substitution not taken place, so you cannot proceed in other. That is the objection.
Let me see.
Your lordship, no, no.
Anyway, let me see it.
And deep privilege.
Item number 10.
Just a minute.
Oh, I'm sorry, my lord.
2 p.m.
My lord, this is, my lord, come up at, my lord, our instance for
Which
extension of
one?
time. My lord, item number 10. 10 too.
Just a minute. 9 is at 2 p.m.
Item number 10
Yes.
has come up at my instance, my lord, my lord, proceedings before, my lord, the commissioner, the mean profit referee is, my lord, continuing. I'm seeking an extension, my lord, complete, my lord, the reference.
Who is your other side?
But bank was appearing, my lord,
When it is expiring? Time frame?
but I believe, my lord, it's either, my lord,
Mr. Dotto is there.
no, not Mr. Dutta is not there.
Last order. What is the last order? Time is extended till 11 June for filing the report of the special referee
I'm grateful.
with liberty to mention.
I'm so grateful.
11.
I'm for item number 11 for respondent. I'm paying for short passover led
Your
by
lordship.
Mr. Honorable.
My lord, I am for the plaintiff, my lord.
Possibly, your lordship.
My lord, this is, today I'm pressing the application GA 15 of 2025, lordship. It is for seeking discharge of the joint receivers, but at the outset, may I apologize that the application is not numbered, the paragraphs are not numbered properly. And this has come to my notice just now, your lordship. So I'm seeking leave that the paragraphs, may I be given leave to correct the paragraphs first, your lordship.
Draw it with liberty to file afresh.
Your lordship, grateful.
Liberty is given, comma, as prayed for.
Your lordship, I apologize firstly, your lordship. Possibly, your lordship, this application has already been served. So if your lordship kindly grants the liberty to just put correct the paragraph numbers. If
Let
your
it be
lordship
filed,
so
let it
thinks,
be afresh, because otherwise lot of things are to be done.
all marked in Roman numbers, the main paragraph, the 1 and 2,
No.
those are only those two.
Come, otherwise there will be confusion.
Yes, lordship will come with a fresh application.
Liberty is given as prayed for to withdraw GA 15 of 25 and to file it afresh, since number of typographical errors are there in the application. Now, what
Grateful,
about
your lordship.
GA 15 of 25 shall stand disposed of. Shall stand as disposed of. What about other applications? 99 is, I don't think, pending.
Lordship, that is disposed of, your lordship, my lord. And the other two applications, GA 9 of 2013 and GA 11 of 2021, they are pending, your lordship. But first, lordship, I'm seeking that this application be taken up first because of the reluctance of one of the joint receivers to continue, your lordship. And also,
All right.
Yes.
Let the matter appear in the list on 22nd May.
Lordship, 22nd May, I have some difficulty. If second week of May, your lordship.
15th May.
Grateful, your lordship. Grateful.
15th May is okay?
Grateful, your lordship.
Grateful.
Item number 12. অসীম গোঠাগ্রতা
ডেট করে দিও।
13.
39 for the plaintiff. The defendant is not appearing in this matter. They have, so it's
It will not pass any
No,
order.
it's proceeding ex parte. It is proceeding ex parte. I do not seek any order. Only thing.
What is J2?
GA2 is my application, but it's a suit for delivery and cancellation of certain forged documents.
Certain
Forged documents. My lord, we have taken out an application praying for this, the documents to be sent for forensic examination. Your lordship's pleasure was that we should take out an application for that. My lord, there,
Just a
Java
minute, sorry,
Atomic
please.
Research Center was to file a report. Tensilotum.
BARC does not have any expertise.
This is the fourth authority from which we are.
BARC does not have any expertise. The report of the learned registrar original site dated 11 February 2025 be kept in the record. Copy of the report may be handed over to the learned Mr. Gupta, the learned counsel, appearing for the plaintiff. You check it, then come. Adjourn to 8 May for further order.
Grateful.
Item 14, 15, 16 and 19.
14, my lord, I mean 14, my lord, not
Just a
this
minute.
week.
14, 15.
Oh, sorry.
Keep on.
Item 14.
16 and 19 are separate.
Item 14.
14, not this week, my lord.
14 not this week. Who is your other side?
Mr.
My
Suman
lord,
Datta
other
and
side is
Rajashri Datta.
Mr. Rajashri Datta, my lord, is
And Suman Datta.
and Suman. Aji ki korbe?
All right. Adjourn to 8 May. Now 15.
Item 15, 16 and 19.
These were those,
15 Escrow.
yes, Lord, the applications.
15,
Lordship was hearing.
16, 19. Who is your other side?
I'm for the plaintiff.
I've heard it extensively, but no, that one issue is still there.
The affidavit.
The affidavit
You.
on the last occasion I have.
AO is file, check it.
He has filed it on the last occasion, and your lordship had given us a chance to go through it and see whether it is the same or not. My lord, my instruction is it is the same. We have filed about
The AO to the
G3.
Agette
What about you? What do you have to say on para 6? Have you seen this?
Yes. Lords will again, Lords, I would request your lordships to see the escrow agreement and the share purchase agreement. Lord, if your lordships come to
No, so far as escrow agreement is concerned, all the parties are signatory, no doubt. Escrow holders are signatory, but the escrow holder, there is no arbitration clause. There should be a reference to arbitration clause that is provided in section 7 sub-rule subsection
by reference. That is what
that is not meant here.
Lord, the judgments which we have cited before your lordships will find that when two documents are interlinked or interconnected with each other.
But there must be very clear stipulation that you are referring to that document.
But the stipulation is there in the agreement itself. Lord, if your lordship sees the share transfer agreement and the.
And second thing, what another question was raised by me.
Yes.
This agreement, this escrow agreement says whatever the escrow holders or whatever the arbitrators will say, that will be binding. Whether that leaves any scope for arbitration or raising any dispute.
Lord, if the disputes are referred, it goes lock, stock, and barrel to the arbitrator to decide in terms of the share transfer as well as the escrow. Lord, kindly envisages the situation. Lord, this is my most respectful submission that without the share transfer agreement, there's no cause for the escrow agreement.
All parties are appearing here today?
Yes, Lord, all parties. Lord, without the share transfer agreement, there was no reason for the escrow agreement to have been executed. Lord, any dispute which concerns even touching upon the share transfer agreement or the escrow agreement has to go to arbitration, and that is provided for in the clause.
What is your answer to this?
Lord, if your lordship kindly takes the arbitration clause itself.
There is no arbitration clause in escrow agreement.
No, not in the escrow agreement. In the
share transfer agreement.
देखिए to application.
That is in GA3.
That is in J6.
Annex to GA3, my lord.
610.
Yes, my lord. 610. In the event of any dispute or difference arising by and between the parties they are hereto, either concerning or touching upon any of the terms and conditions of the contract, the same shall be referred to the arbitral tribunal. The tribunal shall consist of 3 arbitrators. Mr. Anil Chaudhary, advocate, to be appointed as an arbitrator by the sellers, and the company on the one hand, and Mr. Sandeep Agarwal, advocate, to be appointed as an arbitrator by the buyers on the other hand. The third arbitrator shall be appointed by the said 2 nominee arbitrators by the parties. The arbitration proceeding shall be conducted in accordance with the Arbitration and Conciliation Act 1996. The decision of the arbitral in the matter shall be final and binding. The arbitration sitting shall be held in Kolkata, and
That is irrelevant.
So, my lord, the the 2 of the nominees are final here, my lord. One is Mr. Anil Chaudhary, and another is, my lord, Mr.
Anil Agarwal and Sandeep Chaudhary.
Sandeep Agarwal.
Sandeep Agarwal and Anil Chaudhary.
Now, if your lordship kindly takes the escrow agreement. The escrow agreement, my lord, is at page.
Yes, I've seen this.
Annexure B, my lord, page 39.
Yes.
Kindly see.
Para 6. That was referred to last time.
Yes, my lord. And who are the signatories in the escrow agreement, my lord? The escrow holders are, my lord, Sandeep Agarwal himself and Anil Chaudhary. And my suit is against them. Can you see the suit? Who are the parties?
They are the parties.
They are the parties, my lord. Can you see the defendant number 1 is Anil Chaudhary, and the defendant number 2.
So your point is how they can arbitrate?
Yes. How they can arbitrate, because my main relief is against them. My main relief is not against 3, 4, and 5. Rather, they have filed an application for expunging defendant number 5. Another application is pending. So their main application is against the defendant number 1 and 2 is the 2 defendants against whom the relief has been claimed.
All right. Reserving it.
I just quickly respond, my lord, to your lordship's query. Now, my lord, your lordship had specifically inquired where is the reference of the arbitration agreement in the escrow agreement. Now, your lordship has seen, my lord, my learned senior friend has shown clause 6. So, my lord, there is a reference to arbitration in the escrow agreement, 1. And second,
This is not the escrow agreement, Lord. This is the
how there is a reference to arbitration in escrow agreement.
my lord will kindly see.
Decision of the escrow holder shall be final.
Yes. Now, my lord will see. My lord, let us understand the intention of this clause. In the event of any dispute or difference arising in implementation of the agreement, the decision of the escrow holders shall be final. My lord, here your lordship will remember escrow holders is the arbitrator. So naturally, they are referring to the arbitrators here when they are talking of the escrow holders. However, if any dispute is referred to any of the parties to arbitration in accordance with the clause, then escrow holders shall keep the escrow amount with them till disposal of the arbitration. So, my lord, in this clause, the escrow holders are basically wearing 2 feathers in the same cap. As escrow holders, they will be the arbitrator to decide And during this decision, as escrow holders, not as arbitrators, as escrow holders, they will keep the money in the escrow account and not disburse the same. So they are discharging two roles here. As escrow holders, they will hold on to the money, and as arbitrators, they will decide the dispute between the parties.
All right.
Well,
We're
Lord, here,
having it for order.
here I have one answer, Lord.
No, I have.
If your lordship,
Sir, I have-
okay.
So now, my lord, the other thing is, my lord, both the agreements, what was the purpose of this agreement? My lord, as my learned friend has indicated to your lordship, both the purpose was that when a transfer of shareholding is taken place, what will be the modicum of the transfer? So this was mainly the transfers, the shares will be transferred, money will be kept separately. If there are any statutory liabilities, who will meet those? Escrow holders will meet those. Time period was set. So, my lord, both the agreements have to be read together. Now, my lord, the law today is very well settled. If commercial efficacy is something which is in the mind of the court and is brought to the notice of the court, that has to be implemented. So, my lord, there is a judgment which we have showed your lordship on the last occasion. Amit Lalchand, it squarely covers the point. There were 4 agreements referred to in that judgment. My lord, we need not look into it. I'll just give a brief background. There were 4 agreements in contemplation in that judgment. My lord, one did not have an arbitration clause. The others had. Now, my lord, dispute arose. My lord, this was with regard to setting up of a power plant, a solar power plant. So, my lord, dispute arose between the parties.
Yes, by reference, it can always be section 7, subsection 4 makes it clear.
Everything
And
has
if
to
that
be
be
read
intention
together.
of the, if that be the intention of the parties, that is to be resorted to.
My lord, all the, in these kind of cases, all the agreements, there may be several agreements to bring about one transaction. All the agreements have to be read together. And in these cases, it doesn't matter if only one of the agreement doesn't have an arbitration.
All right.
The intention of the parties have to be clear.
Just, Lord, since I'm the applicant, I'll just close by saying this. If my learned friends have any, Lord, apprehensions as to who is the arbitrator, Lord, the power your lordships have to appoint an independent person as an arbitrator to adjudicate upon the disputes. I'm not standing, Lord, the law is very settled, Lord, that it has to be in accordance with the agreement is not. But Lord will appoint an independent person to adjudicate upon the disputes. Lord, that is number one. And Lord, in answer to your lordship's direct query from which has fallen from your lordships will only have a look at clause 6.2.25 of page 19 of my application. Lord, a direct reference to the escrow agreement, and Lord, more importantly, Lord, the 30 lakhs which is
para 6 point.
Lord, para 6, Lord, clause 6.2.2.5 of the share.
Just a minute.
I'm
2.2.5.
Lord, right dispute between the parties. It is referred to in the share transfer agreement, making a reference to the escrow. And Lord, in addition to this, lordships will also find what is the purpose of the escrow agreement from the last clause in the escrow agreement. Lord, page 43, if your lordships are pleased to come. Lord, clause 7. Lord, lordship sees clause 7. Lord, this is the understanding in which the parties execute the escrow agreement. It is expressly agreed and understood by and between the so-and-so group and the so-and-so group that the escrow holders have extended their good offices only to facilitate the smooth reference transaction between the so-and-so group and so-and-so group. And apart from keeping the escrow amount in its custody in the manner above, the escrow holders shall not have any manner of obligation or liability under any circumstance. So, my lord, they are only facilitators of the transaction which takes place in accordance with the share transfer. So, when my learned senior friend says that, Lord, I have a relief against the escrow holder, Lord, lordship will see the clause. Lord, the intention of the parties is very clear to give effect to the share transfer agreement through the device of, Lord, the escrow agents. Lord, and if any disputes arise, Lord, the agreement provides for, Lord, the solicitors to be appointed. Lordship will appoint a, Lord, independent person. Lord, and Lord, lordship will only, I'm grateful to my learned senior friend, Lord. She points out, Lord, that page 16 of the plain, lordship will find that 30 lakhs which was referred to in that clause, Lord, that is the exact relief which my learned friend, senior friends are seeking in this suit. Lord, so therefore, Lord, on a reading of section 8, lordships will find the disputes, whether it be from the share transfer agreement, directly refers to the escrow agreement, has to be referred to arbitration. Lord, I'm relying. That is the intention. Lord, that is the intention of
Judgments are given, the notes of arguments are given here. All right, reserved for order.
So grateful.
Lord, just one reference, Lord, in reply, Lord.
Just a minute. I am hearing now reserve for order means this is
Lordship disposes of GA3, my lord, the suit goes and my lord, we are
All the
before
connected, yes, all the connected.
GA3 is the main.
GA3. This is the GA3.
Yes, my lord.
And Peter Dolier wrote a bullet
Reserve
down.
for order in GA3 of 22. Other matters are kept pending.
Peter Dolier দাবা আছে? I don't know.
My lord, if your lordship kindly, just in reply, one short point, my lord.
একটাই judgment দাবা রয়েছে?
If your lordship kindly looks at the escrow agreement. Here, my lord, your lordship will find at page 3, at page 41.
তাহলে কি অমিত লালখান দাবা রয়েছে না বিদ্যা দলিয়া দাবা রয়েছে?
Anil Chaudhary, Sandeep Agarwal are the parties
বিদ্যা দলিয়া we have a copy.
in the escrow agreement.
I have with the Drolia and in re-arbitration both.
When in doubt, my lord, refer to arbitration, only that part.
They are the parties. And what is the purpose of the escrow? And why the suit
Yes, I have
has
seen this. I'll pass order.
only one point, my lord. Kindly see in the next page, at page 4, clause 3. Why the suit? In the event of its transpiring that there is any other statutory liability of the company pertaining to the said period up to 31st March 2014 from those disclosed in Schedule 3 of the said agreement within a period till 30th of September 2016, Asian Group shall approach the escrow holders with the details thereof, whereupon the escrow holder shall release the payment to the Asian Group out of the said sum of rupees 30 lakhs on account of such liability. It is clarified that out of the said sum of escrow amount, a sum of rupees 15 lakhs is earmarked for meeting any liability on account of unclaimed claim towards gratuity as per Annexure A to the agreement, which amount is to be in addition to the amount of gratuity list in the Schedule 3 to the said agreement. The payment of 15 lakhs towards the unclaimed gratuity liability will be made directly to the verified claimant. The balance 15 lakhs can only be utilized if needed for payment of gratuity liability.
Statutory liabilities.
Yes.
I have seen this.
Till 31st March 2014. But till 2014, there is no claim before the escrow holders, my lord. Since there was no claim, my lord, we have asked for release of the escrow, the amount that has been held by the escrow in the escrow account. Since they did not release in spite of repeated requests, repeated reminders and demand, my lord, ultimately we had to file the suit. This is the simple suit.
All right.
And it has nothing to do with the main agreement, my lord, because there is no dispute regarding the first agreement. Share transfer. Share transfer is complete.
All right.
And my lord, I have given my judgments also, my lord, regarding that.
Is it there?
Yes, my lord.
Compilation of your judgments and notes of argument?
Yes, my lord.
All right. I'll consider.
Great, my lord.
Interesting. If the interesting law points are there, everyone becomes patient. It demands attention. Yes.
17.
17 I prefer not today, but I have led by Vikas Ranjan Bhattacharya and today due to the death of
Adjourn to 8 May.
Eighteen.
Well, with regard to 18, I was supposed to file an affidavit in opposition, which has not been filed, my lord. My lord, I pray for 2 weeks' time for extension.
Affidavit in opposition is yet to be filed. The same should be filed within 2 weeks. Semicolon, affidavit in reply, if any, within 2 weeks thereafter. 8 May. Not 8 May, it will come in the list on 13th May.
Item 20.
My lord, I appear on behalf of the petitioners, my lord. My lord, it is my application, my lord.
What is G1?
My lord, this GA1, my lord, is an application, my lord, by which I have sought for the amendment, my lord, in the affidavit of assets for the inclusion of a bank account which belongs to the estate of my deceased father-in-law, my lord. My lord, and on the last occasion, I had called for a report from the bank regards the existence
That
of
is
the.
yet to come.
No, my lord, that has come, my lord. My lord, because my lord had heard the matter 2 weeks earlier, back then my lord had sought a question from
Estate of late Bajrang Prasad
yes,
Jalal.
yes, my lord, yes. So my lord, the letters of administration in respect of the will of my deceased husband has already been granted, my lord, in the year 2022.
No, there was an order, bank to
Yes, my lord, the bank was
দেখি order
supposed-
sheet টা দেখি। The original will was directed to be placed here.
My lord, may I submit one thing, my lord,
Just a
with
minute.
your permission?
ছেড়ে দাও, order করে দিচ্ছি। The instant application, এই এটা কোথায়? Master summons? Is filed by the executor praying for amendment of affidavit of assets. Full stop. It is pleaded in the application that one assets maintained in a bank account being number 8 লেখো তো।
My lord, that is indicated in page number 52 of the application, my lord. The amended
No, no, you
affidavit.
have pleaded here.
Yes, my lord. Yes, I have pleaded, my lord.
না না, ওই যে নিচে 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 হুম হুম ওটা দেখে লিখে নিও। Did not figure in the affidavit of assets. Full stop. Next para. The will
My lord will find the will.
in question is very specific. Semicolon. The testator devised and bequeathed the cash in bank accounts, fixed deposit, and other liquid assets after meeting statutory liabilities, comma if any, to his son Sandeep Jalan, who is the propounder of the will herein. Next para. Amended the affidavit. The proposed amended affidavit of asset is filed herewith. Let prayer ABC of the master summons be allowed. G1 of 24 is disposed of. Department is directed to do the needful. আচ্ছা আগে একটা কথা লিখে নাও, পেরুস্তি প্রথমেই দেখো পেরুস্তি report submitted by the learned registrar original site dated 15 February 2025. Full stop. এটা প্রথমে কন্টিনিউ করো ওটা। It is in the report that the branch manager of HDFC Bank Limited, Constantia Building, 11 Dr. UN Brahmachari Street, Kolkata 17, send a communication dated sent a communication wherein it is confirmed that the account number, এটা লিখে নেবে, same account number হবে, is standing in the name of the estate of late Bajrang Prasad Jalan. And the authorized signatory is Sandeep Kumar Jalan. বাকিটা লিখে দিও, যা যেটা প্রথমে লিখে নেবে।
My lord, I tender my apologies to you for my conduct on the last occasion, my lord.
বেশ করেছো,
My lord, I'm extremely sorry, my lord. It will not be repeated, my lord.
বেশ করেছো।
21.
And my lord, I am appearing on behalf of the petitioner, my lord, in this matter. It is I'm praying the citation may be issued, my lord, as per prayer A, my lord.
Special or general?
Special citation, my lord.
Special citation to whom?
To whom, my lord,
Have you named anyone?
Tonusri Roy, my lord. That is prayer A, my lord, my prayer A.
It is amended. It was amended
yes,
earlier.
Yes, my lord.
So extensive amendment.
Because, my lord, initially.
Let special and general citations be issued. By the concerned department. Let the matter appear in the list on 28th May.
My lord, 28th
May.
0.
22.
Who is for the petitioner? Not today. Not this week করে দাও।
Item number 9. Wait, please, your lordship. Lord, I appear for the defendant number 2.
And for the
For
plaintiff.
my arguments. The last occasion, my lord, if your lordship sees the order of 19th of February 2025, Lord, we had prepared the compilation of, my lord, the pleadings filed in the suit, my lord. We have filed it. Yes, my lord.
For its recovery of possession.
No, my lord. This is pertaining to, my lord, a money claim made by the plaintiff on the defendant numbers 1 and 2 as a result of, my lord, the funds being taken out of the bank account of the plaintiff, which was maintained with the defendant number 1 bank. The defendant number 2 was the internet service provider and the telephone service provider, Vodafone. Lord, for a certain span of time on a particular day, my lord, the connection of the plaintiff was disrupted and it was shut off. When, my lord, according to the plaintiff, my lord, there was a defalcation of funds to the extent I am for the defendant number 2, which is, my lord, Vodafone, the internet service provider. So, my lord, we have already concluded the cross-examination and the examination of all witnesses. This has come up now at our instance for, my lord, hearing of the suit. Yes, my lord, for arguments. May I commence, my lord? As my witness was last in the box, my lord, your lordship directed me to start with the arguments. Lord, we have also prepared, my lord, a compilation of, my lord, the deposition of all the parties, my lord. May I file the copies? Yes, my lord. Yes, my lord. Lord, it's one defendant of one witness of the defendant number 1 and one witness of the defendant number 2. Defendant number 1, my lord, is Corporation Bank.
Now it's Union Bank.
Now it is Union. Each party produced one.
Did we see the issue?
Yes, my lord. The issues have been framed.
160.
My lord, at page 160 of my compilation, not this one, the one with the pleadings.
Page 160.
116.
160.
These are the issues, my lord, as recast by your lordship in January 2020. May I now commence, my lord, my submissions? My lord, the brief outline of the case is this, my lord. The defendant number 1 has had a connection with the defendant number 2, and my lord, defendant number 1 has a bank account which is maintained with the defendant number 1 bank. The plaintiff number 2 is, my lord, the director of the plaintiff number 1. The plaintiff number 2 operates this bank account as well as, my lord, the mobile number provided by the defendant number 2.
That mobile number is linked to this account.
Yes, my lord, it is linked to this account. Now, my lord, on the fateful day, the plaintiff's case is that the plaintiff's mobile phone was switched off because, my lord, allegedly, my lord, according to the plaintiff, for 5 hours they did not have connection and they had visited. Yes, out of connection. Why? I'll just indicate, my lord. Because in those 5 hours, my lord, there was a SIM exchange happening. As in, my lord, the SIM was being replaced. In the interregnum, in that 5-hour span, my lord, funds which were lying with the defendant number 1 bank to the extent of around 30 odd lakhs was withdrawn, according to the plaintiff, without the plaintiff's authority. So, my lord, when these funds were taken out, according to the plaintiff, by, my lord, 7 persons whom the plaintiff identifies in the plaint, names them in the plaint, but surprisingly, my lord, the plaintiff does not make them parties, neither do the plaintiff sue any one of them for these funds which have been withdrawn. The plaintiff sues the bank and, my lord, the internet service provider. My lord, the defendant number 2 being the internet service provider is only an intermediary in terms of, my lord, the Information Technology Act 2000. The system which is maintained by the bank will only operate once, my lord, a request is made to the bank for online transfer by adding of a beneficiary, which can happen at the instance of the plaintiff, and, my lord, and upon that request being made, once an OTP is generated by the bank, which will be provided to the plaintiff through the internet service provider, and upon validation of that one-time password, which is the OTP, will the transaction take place. It is the case now which has been run by the plaintiff that they did not have any knowledge of these transactions. They were completely in the dark. The documents which have been seized pursuant to the criminal complaint made by the plaintiff shows, my lord, the documents which had been furnished. There is definitely it is the document which is of, my lord, the plaintiff. The discrepancy is this, my lord, that in the original application form, which was almost 20 years back when the plaintiff took the number,
Application for connection.
For the mobile phone connection, the original document which was submitted then was the driving license, and now which has been furnished is the voter ID card. This is what it is. The plaintiff, on coming to know that his phone is not operational, he visits the store of Vodafone. Whatever steps are to be taken has been taken. But what is surprising is this, my lord, that the plaintiff, for a span of 7 days from the date when his phone got disrupted and disconnected, till, my lord, around 7 days after that, he did not inquire from the bank as to anything. There was reduction of funds to the extent of 30 lakhs. However, the plaintiff took no steps. It is his plaint case, my lord. Now, my lord, may I place the plaint once? So initially a plaint was filed, subsequently it was amended. So I've included the amended plaint, which is at page 1 of, my lord, the compilation.
Yes.
Paragraph 5, my lord. The plaintiffs were given to understand that in order for any transaction to be successfully made through the internet banking or mobile banking facilities, the same would have to be authorized through the aforesaid registered mobile number, where a unique authorization code referred to as a one-time password would be sent before the proposed transaction can be effected by the bank. Ever since the plaintiffs applied for the internet banking and mobile banking services in the year 2009 as aforesaid, the registered mobile number maintained in the records of the defendant number 1 bank was such and such, being a Vodafone connection maintained with the name of the plaintiff number 2. The internet and mobile banking services brought with it a spate of fraudulent transactions. This gives the background of various fraudulent transactions. Well, I'll skip over all of that and come to the more relevant part. Paragraph 11. At page 11 of the compilation, in spite of existence of a seemingly foolproof page 11. Paragraph 11, page 11.
Paragraph 11.
Yes. Running page 9 of the plaint,
Yes.
page 11 of the compilation.
Yes. In spite of existence
of a seemingly foolproof mechanism to prevent bank fraud, the plaintiffs became helpless victims of one of such mischievous activity perpetrated and or facilitated by the defendants jointly and or severally on October 26, 2016, whereupon the plaintiff suffered a monetary loss to the tune of about 34,75,000 within a span of 30 minutes between 1:58 p.m. and 2:27 p.m. The fraud was perpetrated by the persons here below named, who are beneficiaries of the sums illegally and unauthorizedly debited from the current account maintained by the plaintiff number 1 with the defendant number 1 bank. The plaintiff identifies the beneficiary accounts where the funds have been transferred from the account of the plaintiff. Shujauddin Maulia, then my lord Suresh Singh, Vishal Singh, Rintu Shaha, and my lord Deepak Chaudhary. None of these persons are made parties to the suit. The fraud perpetrated on the plaintiffs could not have been possible without the active aid, assistance, collusion, conspiracy, and connivance of the officers and staff of the defendant number 1 bank, as also the men, agents, staff, and officers of the defendant number 2 Vodafone. The modus operandi adopted by the above named persons with the active aid and assistance of the men, officers, and staff of the defendant number 1 and 2 to defraud the plaintiffs is chronologically described here below. October 26, 2016, at about 12:17 p.m., the plaintiff number 2 received 2 text messages immediately, one after another, from Vodafone, being the defendant number 2 herein. The first text message stated that the plaintiff number 2 had applied for replacement of the SIM issued against mobile number such and such. The second text message sought a confirmation from the plaintiff number 2 by selecting either Y or no as to whether such plaintiff had applied for replacement of the SIM card. The 2 text messages were separated by mere 10 seconds. The text messages were received, my lord, at the address provided, Swallow Lane. Even before the plaintiff number 2 could respond to the second message by selecting the option no, which is represented by the letter N, to signify no such request for issuance of a duplicate SIM card had been made by him, the mobile connection of the plaintiff number 2 was disconnected. The plaintiff number 2 immediately rushed to the store authorized outlet of the defendant number 2 at Stephen House within the jurisdiction of the aforesaid court. In the meantime, the plaintiff number 2's son contacted the customer care helpline of Vodafone, the hearing to intimate them that no request for issuance of duplicate SIM had been made by the plaintiff number 2. However, the plaintiff number 2's son was informed by the customer care executive that duplicate SIM had already been issued by the defendant number 2, and the same had also been activated somewhere in North Central Calcutta through a store of the defendant number 2, and that was the only way available to deactivate said duplicate SIM card was by way of filing a formal application in one of the retail outlets stores of the defendant number 2. Meanwhile, at the retail outlet of the defendant number 2 at Stephen House, the plaintiff met with one Anirban Homik, store manager, and apprised him of what had transpired. The plaintiff number 2 was told that a duplicate SIM card had been issued in the absence and without him having furnished relevant documents as proof of identity. The plaintiff number 2 explained to him that no such application was made by the plaintiff number 2 under his instructions. It was impossible for someone to produce any original proof of identity on the basis of which a duplicate SIM card could be issued. The plaintiff number 2 insisted that a copy of such purported application be shown to him, but to no avail. The plaintiff number 2 was asked to surrender the SIM card which was lying with him and to submit a copy of the identity proof in order for the process of deactivation of the duplicate SIM card to be started. The plaintiff number 2 was also asked to show the original photo identity proof of the representative of the defendant number 2, without which apparently no application could be considered by Vodafone for issuance of the duplicate SIM card. The entire process took almost an hour to complete, after which the plaintiff number 2 was asked to come back to the outlet after an hour to collect his duplicate SIM card, by which time it was already 1:30. The plaintiff number 2 went back to the retail outlet at about 2 p.m. when he was given to understand the outlet was yet to obtain approval from the head office of Vodafone and was asked to return to the outlet at about 5 p.m. The plaintiff number 2 was finally issued a duplicate SIM card from the retail outlet at about 5 p.m. On 2nd November 2016, the plaintiff number 2 visited the Brabant Road branch of the defendant number 1 bank. So, on the 26th October, this happens that somebody allegedly applies for a duplicate SIM card. His original SIM card is deactivated and a duplicate SIM card is issued. From 26th October till 2nd November, my lord, there is no interaction between the plaintiff and the defendant number 1 bank. It is quite surprising, my lord, within the jurisdiction to collect a bank statement of the current account. It is only then upon perusing the bank statement and upon making further inquiries, the plaintiff number 2 was astonished to find that on October 26, as many as 6 debits were made from the account of and an aggregate sum of rupees 34.75 lakhs were in favor of the persons named in paragraph 12 here and above by RTGS transfers, although none of the RTGS transfers or transactions made on October 26 were made by the plaintiff. So, my lord, he indicates that there was, my lord, there was deactivation and issuance of the duplicate SIM, but 6-7 days he didn't approach the bank. The RTGS transfers were all made between 117 to 155, during which period the mobile number was deactivated. IP address from the internet banking of the plaintiff's account was accessed different from the IP address from which the plaintiff would usually access. It was apparent that the whole incident was pre-planned and could not have been successfully pulled off without the collusion and connivance of the staff, officers of the employees of the different number 1 and 2. Bank statement here is disclosed, my lord, and there the entries have also been disclosed. The plaintiff number 2 thereafter lodged a complaint. When the complaint is annexed, my lord, he relies upon, my lord, the guidelines of, my lord,
RBI guidelines.
Yes, my lord, with regards to internet banking. Plaintiff states that the defendants and each of them clandestinely and acting in league and concert with the person's name in paragraph 12, my lord, have perpetrated fraud. Paragraph 18 is of utmost
For this
relevance.
fishing out, you are blamed.
Yes, my lord.
Along with the defendant number 1.
Yes.
So the
Now-
bank and the service
And the
provider
service
both are
provider
blamed.
is blamed. What is important is paragraph 18, my lord, of the plaint. The plaintiff makes out this case that the defendants and each of them clandestinely acting in league and concert with the person's name in paragraph 12. Which are those 6 persons to whose accounts these transfers have been made? They run a case of fraud. They run a case of collusion and connivance, but it is only the defendant number 1 or the defendant number 2, not those persons to whose account it's been transferred. The mode and manner in which the defendants perpetrate fraud on the plaintiffs and which may be treated as particulars fraud, well, the particulars as usual are the necessary pleadings are there with regards to fraud, Miller. I won't trouble your lordship with that. As aforesaid, the defendants, paragraph 20.
What is your reply?
Yes, my lord. My response to it, my lord, first and foremost, is with regards to, my lord, the maintainability of the suit as against the defendant number 2. Because, my lord, in terms of, my lord, the Information Technology Act,
Where is your written statement?
well, it is part of, my lord, the compilation, which is at page
109.
109.
Because for the timing, I will look into your defense.
Yes. Without going into the aspect of maintainability, if I may answer this, my lord, the defense which I have is 1,
Actually, your WS starts from 121.
yes, my lord. Before that, all the, my lord, the compliance of, my lord, commercial division is there.
Hmm.
It starts from 121.
And WS of defendant number 1 starts from?
It starts at page 52, effectively, my lord. It actually starts from
54.
54. My lord, my defense is at page 123, paragraph 2I. Before that is all the compliances that are requisite. We have indicated that.
I'm not going into those particulars.
Yes, my lord. May I place the defense apropos, my lord, the replacement? On 26th, lordship has that?
Yes. On 26th
October
October,
20th, yes,
a request was received
yes, my lord.
for change of SIM.
Yes, my lord. After due verification of the said documents at the said Vodafone mini store channel partner, the request so received by the said franchisee store was processed in good faith by the defendant number 2 under an
Now,
impression.
tell me
that-
one thing.
Yes.
This request was received at Srirampur.
Yes, my lord.
What is the registered address of your plaintiff number 2?
My lord, the plaintiff number 2's address is at Hare Street.
At?
At Hare Street.
Then why it was entertained?
My lord, when
Did
the
not even, it should raise suspicion.
So what we inquired, my lord, that evidence is there. My lord, it's these stores, these are not effectively, my lord, as a agent to principal relationship. It is not. It is principal to principal. So, my lord, today I can only have a contract on a principal to principal basis. And my lord, if at the end of the store, they take a document and verify, yes, the person who has applied is the person whose SIM it is. They have verified the documents and my lord, they have issued the SIM. That is what has happened.
How this person is supposed to know who is the principal, who is the agent?
Because, my lord, they can verify, not the principal and agent as far as that is concerned. The person who's applying, his records with regards to the original customer application form, that is verified. My lord, whether the person, the name and the respective particulars are the same. May not be the document, but the other particulars matched and that's why it was issued.
Who issued the original SIM card? Of course, Vodafone.
The SIM card is Vodafone. SIM card is Vodafone. There cannot be any, nobody else can, because it is without the registered owner of the SIM, it cannot.
But what pinches me is that this application was received at Hooghly.
Yes, my lord.
And this person, this particular store, did not care into the fact that the person was residing in Hare Street.
Yes, my lord.
And why he should
Why
make an
did he go
application?
to Srihampur? I had also inquired of my clients as to why would he have to go to Srihampur and wouldn't that question arise? That's why, my lord, the business model was that it is on a principal to principal basis.
Whatever that might be.
That is the problem.
Anyway.
The request to receive by the franchisee store was processed in good faith by the defendant.
And whatever that might be, franchisee or whatever that might be, a store issued the duplicate
yes,
card.
Absolutely.
And in the meantime, mischief was done.
Yes, my lord.
Or after that, mischief was done.
After that, mischief was between the time, my lord, the original SIM was deactivated and intimation to Vodafone by the plaintiff. Between these two timelines.
During this interregnum period, it was done.
Yes. But the intimation with regards to the mischief came only after, my lord, a lapse of 7 or 8 days. As per common banking practice, this is paragraph J, my lord, 124. Different security measures are followed. The customer is required to submit his user ID and password, which is confidential.
Your point is neither of the defendant number 2 nor employees have access to the user ID, password, so and so.
So, my lord,
any access to the particulars.
Yes. Firstly, my lord, it is not just access to the particulars. Lordship knows once internet banking is activated, for transfer to be effected, a beneficiary has to be added. For the purpose of adding that beneficiary, also username, password, and, my lord, one-time password is required. This neither am I at the generating, nor am I at the generating end, nor am I at the request receiving end.
Defendant number 2 or its employees had only approved the activation of the number on the basis of documents.
All inputs in the form of username, password comes from the end of, my lord, the account holder.
What is SIMEX? Para M?
Well, that is SIM exchange.
SIM change rather.
SIM exchange because, my lord, once the duplicate SIM has to be issued only when the original SIM is
surrendered. Then what happened to the original SIM?
It has to be destroyed.
Once they accept, according to the plaintiff number 2, the original SIM, there was no connection for 5 to 8 hours.
Around 5 hours.
Around 5 hours. 5 hours. So very good. Then the new SIM was issued.
New SIM is issued.
What about the original SIM?
That SIM was deposited in Calcutta. Because, my lord, as soon as he came to know it's been deactivated, the plaintiff approached the Vodafone store at Calcutta Stephen House. So we immediately took steps to have it deactivated, the other one, and to have it reactivated. So in that interregnum, the entire transaction happened. So the original SIM was with the plaintiff till the time he surrendered for the reactivation.
All right, then what you would say?
So, my lord, with regards to
So your point is that
twofold.
First, no, number of points are there. First, necessary parties are not here.
No.
That is those who have actually done the mischief. Second thing, your role was very limited.
Yes, my lord.
On due verification, issue of new SIM.
Yes, my lord.
So you are not responsible for fishing out.
No.
And third thing?
Third is, my lord, the maintainability of this suit insofar as Vodafone is concerned, because in terms of, my lord, the Information Technology Act, I am an intermediary. A civil suit against an intermediary wouldn't lie before a civil court. There's an adjudicating authority established by the rules of, my lord, the Information Technology Act. All challenges or all claims made against, my lord, the defendant number 2 has to go before that.
All right. These are your 3 points.
These are the primary points. And apart from that, my lord, that the plaintiff has also, in his plaint case, has alleged everything against the other 5 defendants who have not been impleaded. Despite of which, my lord, no reliefs have not been impleaded and no reliefs paid for.
Under section 61 of IT Act.
Yes, my lord.
That point is taken R.
S, my lord, R and S.
RSU.
Yes, barred under 61.
Basically from R to U.
That is under
61 case.
61 issue. And the rest is, my lord, with regards to, my lord, the...
Very good. Come on the next on information technology.
Yes, I'll do that. And I'll also indicate, my lord, in the evidence and the deposition of the plaintiff, there are a lot of discrepancies where he admits that the password has to be generated by him. He admits it.
Come on the next.
I'll show those depositions.
Or Mr. Ghosh, the learned counsel for the defendant number 2 in part. Fix. After this vacation, coming week. 25th April for further argument.
Great.
Who is for the bank?
Bank. She is not here. Would it be my lord's pleasure to inform them? I shall write a letter and
the bank.
I'll inform them.
For the bank.
No, Lordship, I'm for defendant number 1.
Bank.
Oh, bank.
So, notice that. Next day.
Anyway.
Lordship, actually, I was just briefed about that.
No issue.
No.
For arguments, item number 23 and 24.
For the plaintiff in this matter.
Where is Mr. Deb?
He's supposed to come. He's supposed to come.
He has asked me to.
Done. No issue. It's done. It is adjourned. I've heard in defendant number 2 in part. It is further hearing. It is adjourned.
My lord, this is the
preliminary issue.
Whether the suit is barred by section 31 of FERA. That was the point. Now I have told you the 4
section 31 of FERA prohibits certain transaction. Prohibiting transaction is whether tantamount to bar of the suit. That was my
and for that I have given your lordship the example. Let's say, assuming that the specific performance is, what is their case? That section 31 does not allow a foreign national to enter into even an agreement for sale. That is their concern. So since I have filed a suit for specific...
Basically, this FERA did not provide for an alternative forum or tribunal.
Absolutely. There is no, not only that. Absolutely. I bow down to that. It does not say that the civil court will not entertain a suit regarding this, nothing of that sort. Like my lord, DRT, Securitization Act, I will give your lordship that chart. But more fundamentally, what I told your lordship on the last occasion also, say for example, and without admitting, I am saying if 31, the best case they can run, 31 bars, even
Your claim.
the entering into of an agreement by a foreign national.
In that case, you can ask for refund of money. That alternative remedy you can ask for.
That prayer is there in the suit. That in case the court will not grant specific performance of this agreement, refund my earnest money. Now, to that extent, will your lordship say, is any court, can any court say that no, suit is not maintainable?
Court can do, whether that's logical.
Absolutely. Question is, ultimately, all law, the basics, the bedrock is logic. Very well. Assuming that specific performances cannot be, ultimately your lordship may not grant specific performance for other reasons also. That no, I will not grant specific performance. But then the other prayers in the suit are refund of earnest money, interest on earnest money that you have been withholding for all this while. What happens to that? Is the court denuded of powers to adjudicate that? No. In my respectful submission, no. There's the first day your lordship observe this, and that is, I think, that should be the end of the matter. That on this preliminary issue, there is no bar, first of all, no bar in 31 from filing the suit. It only says that a foreign national will not enter into any agreement without permission. So now I am first limb of my submission is,
if that is not done, there will be no agreement, no conveyance, nothing, no transfer at all.
No transfer, and ultimately, so the suit as far as specific performance will fail. But what about the earnest money refund? And section 21, I have made your lordship read of Specific Relief Act, which says, court at any point of time, if it is of the opinion that specific performances cannot be
bar of remedy, not bar of forum.
What more do I say? But just because they have argued so much, let me address your lordship even on the fact that whether at all section 31 bars even the entering into the agreement for sale, because that is their case. I am kindly see section 31 once. My lord, it's there in the compilation. My lord, they have made a compilation. Is there, my lord, 1 to 63, volume 3. Kindly takes volume 3. Volume 3 take check with them.
Volume 3, page.
It's the Foreign Exchange Regulation Act starts
1 to 63.
Yes. Kindly come to page
31.
32.
Yes.
32.
Restriction on acquisition, holding, so and so.
Yes. Now kindly see, no person who is not a citizen of India and no company other than a banking company which is not incorporated under any law in force in India shall, except with the previous general or special permission of the Reserve Bank of India, hold or transfer or dispose of by sale. This is the last part is what we are interested in. Or dispose of by sale, mortgage, lease, gift, settlement, or otherwise any immovable property situated in India. This is the only section they have relied on. And that is the whole scope of the preliminary issue. Now, my lord, the lordship is looking for something else, I believe.
Unless specifically barred, Dhula bhai.
Section 9. Section 9 of the Civil Procedure Code. Civil court can entertain all suits of civil nature unless.
Yes, I got it. What is Mr. Deb? I could have finished it today.
No, my lord, to be on the safe side, let me just deal at least, formally at least deal with what they have argued. Now, my lord, kindly see what they say. So, first and foremost, my first submission with regard to section 31 is this, that section 31 bar.
There is a legal proceeding, bar on legal proceeding.
No, my lord, with the deepest of respect, may I say this? There is no question.
There is a bar of legal proceeding. 70, go look into 78. But that is not in respect of this one. Against the central government, Reserve Bank, so and so.
That is different.
Yes. There is a bar.
Yes.
Bar is there.
But that is against central government and Reserve Bank.
Right.
Exercising any powers. This is my suit. Neither is central government a party, nor is Reserve Bank a party. I am not seeking any relief against them. They are not even a party. I am seeking a relief against the person who had entered into an agreement with me, and now with Mr. Dev's client who have stepped into the shoes of that person. So, my lord, section 78 is nobody's case.
Yes.
Now, my lord, 31, may I take 31 at its highest? What do they say? They say no person who is not a citizen of India shall, except with the previous general permission of the Reserve Bank of India, dispose of by sale, mortgage, lease, gift, settlement, or otherwise any immovable property situated in India. So, what can a foreign national not do? What is a bar under 31? Sale. This is not a sale. She has not sold. She has only entered into an agreement for sale. 2. Mortgage. She has not mortgaged. Helen Wilson has not mortgaged. 3. Lease. No question of lease. No gift. No settlement. This is an agreement for sale. So all the things that are mentioned, sale, mortgage, lease, gift, settlement, Helen Wilson has not entered into any of these transactions with me. The transaction is an agreement for sale. So agreement for sale is not mentioned in 31. But there are
sale will not take place.
Sale. So so the bar of 31 is only when there is a sale, absolute transfer, absolute gift, absolute mortgage. That the foreign national cannot do without having permission from Reserve Bank of India. It does not say 31 that even an agreement for sale cannot be entered into. And your lordship will kindly bear in mind, agreement for sale is what? Agreement for sale is to enter into a sale later on. Agreement for sale itself is not the transfer. No stamp duty.
Yes, I got your point.
But to be fair to them, their argument is, yes, sale, mortgage, lease, gift, settlement does not say agreement for sale. What do they say? Or otherwise. This or otherwise, according to them, brings into its fold agreement for sale. That's the long and short of their argument, if I have understood correctly. Now, that is a completely misconstrued reading of section 31. Why do I say that? My lord,
no, for the timing, if I accept their argument also.
Then also my answer, that answer is there. But I am saying even their argument on merits is
additional.
Why? Because or otherwise, this word or otherwise, your lordship will remember and lordship knows, any word, if 2-3 words are used and then another word is used thereafter, courts have
the otherwise contains according to you a transfer.
An absolute transfer in present or otherwise cannot be of agreement for sale, which is agreement to transfer.
Intention to transfer.
Yes, agreement to transfer at a future date. Because all these sale, mortgage, lease, gift, settlement, contemplate of transfer as on the date of registration. The moment I execute a deed of conveyance, a transfer is effected. The moment I execute a deed of gift, transfer is effected. I will show the provisions of Transfer of Property Act. Immediately upon registration, the transfer effected. But agreement for sale.
For the timing, this argument is enough. Let me, next day I will hear Mr. Dev.
And 2-3 judgments on this, because this otherwise or otherwise, my point is that this has to be.
Have you any judgment right now?
Yes.
Show me.
Or otherwise means, according to us, is usdem generis, has to be of the same genus. Or otherwise cannot be of a different genus. I am saying agreement for sale and sale are completely different. So, I am relying on, so that Mr. Dev can also. I am relying on 1989.
Have you hard copy? Come on the next date.
I'm just giving the reference to them so that they can calculate. 1989 2 SCC 458. And my lord, I am also citing, my lord, no, very well. For this, I am citing this. I will only, my lord, give one more.
Because your periphery now is very limited.
And now I will.
Don't argue the whole case right now.
No, not at all. I'm the last person to do that. Now, my lord, the second limb which I want to address you on the last occasion, on the next occasion, would be that in fact Reserve Bank itself has given an idea as to how Section 31 is to be interpreted. How? By providing of two forms, IPI 1, your lordship remembers that book, IPI 1 and IPI 2. IPI 2 is the form which Reserve Bank has issued, not me, not any other authority. Reserve Bank has issued with regard to Section 31, that if a person wants to sell, the person, a foreign national, has to apply in IPI 2. And what is the first document in that form?
Agreement for sale.
Now, if that is the first document I have to annex with it, I cannot have to have a permission from the document also. Then even there would have been a different form. The first document is agreement for sale in IPI 2. So if I want to transfer, I have to, the first document I have to annex is an agreement for sale. For that, there is no permission required. Then otherwise it could not have mentioned that.
All right, got your point.
But I'll come back and cite only one judgment on that, that even forms and circulars issued by Reserve Bank has force of law. But may I also come back with a...
20 and 25 days.
Anytime next week, Mel?
Next week, 16, 17.
22nd?
Too troublesome, yes.
22nd.
22nd.
Grateful.
Heard Mr. Ghosh in part, you are the defendant.
No,
I'm the plaintiff.
Plaintiff. Heard Mr. Ghosh, the learned counsel for the plaintiff in part. Adjourned to 22nd April for further hearing.
But, there's a matter fixed in the division bench. Can it be 23rd? 23rd or 24th? 24th if it commences to your lordship. If it commences. Okay. 24th. But is it your lordship pleasure we bring a short notes of argument also? Because I believe your lordship has...
You bring those judgments.
With the notes I will bring.
This is, I am hearing specific performance.
576, my lord.
And
what about this one, the other one?
That is EOPLA.
No, CS11.
Oh,
CS11.
CS11. That is a cancellation of will, my lord. That really, my lord, is neither here nor there. This is the main suit. And my lord, the EOPLA. Those have to be...
EOPLA is other.
Yes.
My lord.
This suit. These are the suits that have to be decided.
25.
We're supposed to argue, continue argue.
Yes. Mr. S.N. Mukherjee is arguing. I can continue. And there
The
was
other side is not here.
gentleman from Bombay also was appearing on the last.
He's not here also.
Well, I can start. I can just
In
give
their
a,
absence, how can you?
because of today's resolution, I understand.
Yes.
Then, my lord, will give us 2 or 3 consecutive days. Your lordship has kept that cross-examination 29th, 30th and 1st. If after that or before that, at least if I get a half an hour every day, then we'll finish it. 29th, 30th and 1st. Your lordship has kept my that shouldn't take very long.
22, 24, কবে?
After the 27th, Mr. Mukherjee has requested me, but I'll be here.
After 27th?
28th, 29th, 30th and 1st.
21, 2, 3?
No, Mr. Mukherjee is not there. He requested. I'm there, but...
Then after 28, 29, 30, 1st.
Those 4 days, if my lord gives us, at least we'll finish. Or 3 days. Or 30th,
Come on 2nd May. Come on 2nd May.
Then my lord will give us 2 days because I'll have to get Mr. Mukherjee.
On that day, I'll fix consecutive dates. I am now, my burden is now less, lightened.
Then the holidays will come. That's the thing. Because your lordship, the just...
2nd May, then 5, 6, 7, I can allot you.
5, 6, 7.
I am not passing any order regarding that, but I have in my mind.
Okay. 2nd will come back. We'll come back.
2nd. Adjourn to 2nd May. For further argument. So further hearing. Remind me, I will fix consecutive dates. And when that matter is fixed, stamp duty?
Tomorrow.
Tomorrow.
I'm saying it's supposed to be in the list tomorrow.
Only basically thing is not without my determination right now. That suit is not in my determination right now. Only because it's part heard.
That is it. Your lordship is only hearing an objection to one document, though it's not a vital document, but it's just a quite interesting question of law. That's why we are arguing that.
Come on the next date. Come on the next tomorrow. Yes. Because I have to release this matter. I have no determination to hear this. Or you can agitate the matter before the proper bench. I can release it.
I'll have to take.
Talk to Mr. Bush.
I'm the defendant, so.
Talk to Mr. Bush.
Second, we shall come back.
Witness action, item number 26.
26, I am for the
Witness action is complete.
No, the attesting witness come before your lordship. He was completed,
Other witness is not there.
No, the executor is come. He is a paralytic patient, 79. I filed an application for one commission, your lordship adjourn some time.
Adjourn to 2nd May.
Okay.
For further witness action.
In the meantime, I shall file an application for commission.
27.
Your Lordship, I appear under the plaintiff. On the last occasion, Your Lordship was pleased to take up GS6.
No, not GS6. My point is whether this is a commercial dispute or not.
Your Lordship,
This is very possibly a commercial dispute.
Your Lordship, on this point, I was being led by Mr. Shauti Dasgupta. He had addressed Your Lordship on this point that due to the
So let it be deferred today.
Oblige, Your
Let
Lordship.
witness action be deferred. Not today or not this week.
Your Lordship, kindly makes it not this week because we had preferred an application for commission, for conducting of commission. Which
Yes, that was filed.
Yes, Your Lordship.
I was hearing this thing, but the question is whether this is commercial dispute or not. Very possibly this is a commercial dispute.
Yes, Your Lordship. And Mr. Dasgupta had addressed Your Lordship on this point. So, Your Lordship.
Adjourn to 22nd April.
Lordship, I appear for defendant number 1, Lordship.
Very good. Thank you very much for appearing. Come on the next date. And the argument is whether this is the commercial dispute or not.
Very well, Lordship.